Welcome to Advocating for Dads with Jana Jones.
Welcome back to Advocating for Dads with Jana K. Jones. Jana is a North Carolina family law attorney based in Charlotte. She has spent 15 years helping fathers protect their rights and maintain meaningful relationships with their children through custody disputes and divorce. I'm Lisa Mosby, and today we're talking about parental alienation. Jana, will you explain what it is and how North Carolina courts view it?
Sure. Well, it's kind of a debated topic. The term itself is debatable, and I think that's debatable in family law circles and in some kind of psychology counseling circles as well. But there's really no denying that sometimes a parent can poison their child against the other parent, right? And I think that that's how the court typically is viewing it. They don't necessarily say parental alienation, but I do hear poisoning more from a judge's perspective.
And then in North Carolina custody cases, how do courts define or maybe recognize parental alienation, even though the term itself is sometimes debated?
Sure. So it can be difficult to do because it's difficult to prove. A lot of times, the way you are finding out that another parent is speaking negatively about you to the child behind your back is from the child. And generally speaking, the child is not going to be testifying. So, for instance, if I have a client who gets on the stand and says, "Hey, my son or daughter told me that dad is saying XYZ about me," if there's an attorney on the other side, they're going to object based on hearsay because that child is not there to testify. And a lot of times that's the only way you know, right? If you don't overhear the other parent saying something negatively about you in front of the minor child, then it can be very difficult to kind of pinpoint that that's happening.
And then what kinds of behaviors tend to raise concerns for a judge when one parent appears to be undermining the child's relationship with the other parent?
Well, I can tell you judges definitely don't like it. If they get enough information that gives them the basis to believe that that's what's happening, they will not be pleased with it at all. However, we can't unring the bell, right? And so sometimes for folks coming in for consults with me, they're distraught, they're frustrated, understandably, that the other parent has been doing this and maybe been doing it for years. But the effect that it's had is so hardened into the child now that maybe the child won't come visit with them during their scheduled time if there is an order, or just won't come see them even if there isn't an order. And that can be really challenging because it really is going to depend on the age of the child. If you're dealing with a 3 or 4 year old, they don't know what's going on anyway. You can pick them up out of the car seat and put them in the other car seat. And it is what it is when it comes to exchanging the child or children. But when you're dealing with a 13, 14, 15-year-old and they are saying, "I do not want to see my other parent, period," it's going to be very difficult for the parent who's supposed to be giving up that time to comply with the court's order, right? And they're worried about being held in contempt potentially because they're not following the court's order. But ultimately, if it's the child themselves that has been so poisoned at that point that they don't want to spend time with the other parent, usually the court isn't going to penalize that custodial parent because you can't force somebody that age into the car, right? And so it's a very difficult, challenging situation for parents who feel like, the other parent has tried to poison the child against them to be in. And it's not something that necessarily the courts can fix. The court is there to put guardrails on how custody is handled. And so the court is there to call balls and strikes. You get the child this time, the other parent gets the child this time. But the actual life effects and what's going on is not something that the court can control. And so what I think is always important for parents who feel like that's what's happening is to try to get with a therapist and have their child in therapy, figure out what the root cause is, and see if there is a way to combat that. And that's not something the court's going to necessarily force anybody to do. And so that's something that you're going to want to do outside of the court system.
And then how is parental alienation different from a child naturally pulling away from a parent due to maybe conflict or age-related changes?
Yeah, so it really just comes down to what is the catalyst, right? So is it that there's a dynamic between the child and the parent whereby the child just doesn't want to spend time with the parent independent of what the other parent feels or thinks about the non-custodial parent? Or is it the custodial parent saying, your other parent isn't worth anything. You shouldn't spend time with them, and degrading them and their role in their child's life to such a degree that the child starts to internalize that and then maybe says similar things themselves, right? So if you are, spending time with your child and they're saying stuff to you that doesn't make sense for their maturity level, doesn't make sense for the experiences you've had together, then it's possible that that other parent is speaking poorly about you and trying to poison the child against you.
You said maturity level, and instantly what popped into my mind was as a child gets older, do they tend to how do I say that, play the parents against each other? And can the judge decipher what they're doing there if they're, trying to cause alienation between the two parents?
Yeah, I mean, I think that most of the judges are sophisticated enough to figure that out if given the right amount of information and evidence, and that's generally going to come in the testimony of the parents and what was the relationship like at one point versus another, and is there anything that's changed that might have caused it, right? So maybe one of the parents was supportive of an extracurricular activity and the other parent wasn't, and now the parent who's not in support of the extracurricular activity, the child is acting out against that parent, for instance. That might have nothing to do with parental alienation or poisoning the child. That might just be the child upset, right? And then they're going back and telling the parent that is supportive of the extracurricular, I don't want to go see this other parent now. And so you don't necessarily know for sure. There's what you can prove and the information that you can give, and then there's the truth. And as much as the court tries to get to the truth, they're not always going to be able to get there. So you want to talk to your attorney, and be very candid with what's going on so that you can create the best strategy for presenting the case in the way that you want it as possible. I tell folks all the time, we can work towards getting the court to see things your way, but what we can't do is control the facts. And if our facts are not good, there is not a lot we can do to change those facts.
And you mentioned evidence. What types of evidence are most persuasive in the court when a father believes that the other parent is interfering with the parent-child relationship?
So, when it comes to that, generally the court speaking to the child is probably going to be the best way for the court to get a feel for whether this is a parent in the background doing this kind of puppeteering, or if this is the child themselves, maybe something they haven't disclosed to the other parent as to why they're feeling the way they're feeling, right? So, generally speaking, children who are of suitable age and discretion, and that is relative, but I would say on average, probably 12, 13, and older. They could be called as witnesses themselves in court. I do not like that at all. I think that puts the child in a very difficult position. And no matter how much they want to do it, I still don't like it because it is putting the child in a role where adults should be. And so, my preference with the court considering the child's perspective is to be able to speak to the child in chambers. However, for that to happen, both parents have to agree to it. So, if one parent says, sure, speak to them in chambers, please find out what's going on. The other parent's like, nope, call them to the stand, or I don't want to hear from them at all. You're going to have to call your child to the stand, or the court's not going to hear from them at all.
Can repeated small actions like scheduling conflicts, withheld communication, or maybe even negative comments collectively influence the custody decision?
Um, I would say that's probably going to be a stretch. I mean, when you're in court and you're fighting about custody, you don't get along. You're going to say stuff to each other you shouldn't say. You're going to say stuff about each other that you shouldn't say. People who are getting along and co-parenting never see a courtroom, right? Or they're still together parenting their children together. So the court expects there to be some animosity between the people to a certain degree. It is when it affects the welfare of the child that the court has, concerns, and it gives rise to maybe a decision being made about custody based on what's going on.
And then, Jana, how do judges in North Carolina balance claims of alienation against legitimate concerns about a child's safety or well-being?
So, child safety and well-being is paramount. And so that will always be more important to a court than any potential alienation that might be going on. And again, the court's polar star is the child's best interest. And so even if that child is saying, I don't want to spend time with that parent for various reasons, and the court doesn't believe that there is any kind of danger or risk or anything like that involved in the child spending time with that parent, they're going to give the non-custodial parent some time with the child. And they may recommend counseling. They may order counseling. It does happen on occasion, but it's not as common just because there are a lot of pieces to counseling, right? There's cost and there's availability and there's a number of things. And so the court is reluctant to force that on parents, but would definitely probably encourage it in those circumstances. But that is always going to be their polar star, is the child's best interest. And at its core, that mentality means that the child spends as much time with both parents as possible and practical based on the family dynamic. So generally speaking, the court is going to give some time to that parent, even if the child says, I don't want to spend any time with the parent.
Let's talk about steps. What steps should a father take before filing anything if they believe alienation is occurring?
So I think the first step is to talk to your child, try to figure out what's going on. Did I misinterpret something? Did I do something to hurt your feelings? Did I make you feel unseen or unheard in some kind of way? Take responsibility. None of us are perfect. All of us are human. I'm a parent myself. I'm not a perfect parent, right? I've got a 6-year-old. I'm doing pretty good at 6, but she's going to be 7 next month. That'll be a new world, right? Once you get one thing down, then they're in a new place. And so I think it's important to remember that we're all human. Give yourself a little bit of grace, and try to get to the root cause of what's happening, right? If you don't feel like you've got the tools to do that, or that your child is willing to open up to you in that way, then I would definitely recommend getting some therapists or counseling involved to try to get to the bottom of what's happening. That's always going to be my recommendation, because again, the court is limited. At the end of the day, all a court can do is give you an order. They cannot fix your life, right? Those are tools and things that you're going to have to do on your own. And even if you get the order you want, that doesn't necessarily mean you get the relationship that you want. And so that is going to take work that's outside the courtroom.
And then can a finding of parental alienation lead to a modification of custody or decision-making authority?
I would say it can, but it's usually going to be coupled with some other findings. That on its own is not going to be enough. The court's not going to change custody to punish a parent. They're going to change custody because it's in the child's best interest.
So let's wrap this up. Last question. For fathers who feel their relationship with their child is slowly being damaged, what is important to understand about the timing and documentation in these cases?
So the second you start feeling things are going south, have a conversation with your child. If they're too young, or if the relationship is too strained, get therapists involved, counselors involved, to try to get to the bottom of it. And if you determine based on those conversations with providers and with your child that you believe the other parent is trying to poison them against you, then you definitely want to seek legal counsel to see what your options are, depending on whether you have an order yet or not. There are different requirements for getting an order versus modifying an order. And so it's going to be important to get some legal advice to understand the nuances there.
Again, thank you so much for your insights. This has just been really valuable, and so many people are struggling with this in today's society. So do you have any final thoughts for both sides, fathers, mothers, guidance that you want to leave with them today?
Just try to lead with kindness. That's not always the easiest thing to do. And try to be the bigger person. Again, not always the easiest thing to do. And remember that your relationship with your children obviously is going to extend beyond them turning 18 and graduating from high school. And that's the end of when an order can dictate how your relationship goes. And think about that as you make decisions while they are still of the age that the court has the ability to make orders.
Folks, that's a wrap for today's episode of Advocating for Dads. If you believe your relationship with your child is being undermined and you're unsure how to address it legally, visit lawofficeofjkj.com to schedule a consultation with Jana and her team. Thank you so much for listening, and be sure to leave a review, and subscribe to the show so that you don't miss the next one. We'll see you there.
Thanks for watching. If you like this video, don't forget to hit that like button and subscribe to our channel.
for more amazing videos like this one.